Okay, welcome everyone to this lecture. I have the pleasure to welcome a dear friend, Dr. Rocio Daga Portello. Her title for today is What Does a Typology of Legal Documents Tell Us About the Legal System? The formula in Oriental and Western Arabic legal documents 8th to 15th centuries. Dr. Portello received her PhD from Granada University in Spain on a book of fatwas from Al-Andalus, Al-Ahkam al-Kubra of Ibn Sahl from Cordoba, 11th century. She spent 3 years in Cairo during her PhD, affiliated with Cairo University and the American University in Cairo. After a 3-year postdoc at Princeton University, she moved to the Department of Islamic Studies at the Freie Universität Berlin. Since 2007, she has been teaching Arabic and Islamic Studies at the Department of Near Eastern Studies at LMU University of Munich. Since 2016, she has been a member of the research group Arabic Papyrology Database at the Department of Near Eastern Studies, LMU University of Munich too. Her fields of research are how to edit Arabic legal documents, Islamic law, fiqh, Christian Arabic literature, and history of Al-Andalus. Please join me in welcoming Dr. Portello to AUB.
Thank you very much. It's a pleasure to be in this wonderful country, and it's a pleasure to have a lecture in person after so many years. And in this travel time, I come just with a topic that I hope it will be useful for you in some way. We are working especially with documents at the University of Munich. And just to let you know how much work has to be done, I show you the number of documents that you have. You have archives, collections that are archives in themselves. So we have in Berlin 24,000. The Cairo Geniza, the famous one, is also 20,000 documents. We have documents from the Cathedral of Toledo, around 1,000. The Haram documents of Jerusalem also around 933, and so on. So in total you have 40,245 documents, and published are only 4.2% of this. So you just realize how much work. And then you have also the single documents. They are not part of an archive in themselves. They are just single documents, and the most of them are to be found in the Austrian National Library, 18,000 documents. They are also in Germany, in the US, and published has been 5% of them. So this is a big, huge field of research, and we are working. We have a database that helps for the edition of these documents, and this is the papyrology, the Arabic Papyrology Database, and I will show you the real one. I hope I can. I have in Firefox, I call it before, so it's here. Yeah. This is, you just have to type Arabic Papyrology Database, and you get the home page. It's just a little bit slow, that's why I try to, but it's fine. I mean, and then you have here, you can look for documents, text of documents. You have a lexicon, you have the typology of documents. You have a paleography tool also, bibliography, and so on. So if we just look at documents, let's see, why it's happened here now. I'm not, yeah. So you can find, if you have the name of the document, or if you have the inventory number, or if you want just to look for the documents in the database from year to year, or the material. I mean, we have from blackboard, bond, eggshells, leather, paper, papyrus, parchment, and so on. And you have also origin. The origin, well, let's look for Fayum, for instance. And then you search, and you have all these documents. You have 800 documents. You can also look for documents with full text only, then you have a little bit less. And here you have the text. Some of them, they don't have the text, the whole text, but many of them, they have the text, sometimes the image of the document, and also the paleographical data. And here we have been published, because all of these documents have been published, so they are published or mentioned, and so on. So the text, we can go to the text from here, but let's go here also. And the text, in the text you can look for words. So let's say I will write, I hope I have Arabic here, because you can look for Arabic or lemma or transliteration, roots, and so on. And I will try to see if I have Arabic here. No, I don't have Arabic. Where do I change that? Okay, or if not, I will. I have to change to lemata, but no, let's see Sharia, it's better. And the transliteration, I think I'm going to leave this because the transliteration, I'm not sure, I don't have it here. I have it in my computer, but here I don't have it. So, yeah, if you can change, I don't. I usually go up and change the language, but now I don't find here. Arabic, okay. Yeah. Okay. Yeah. Thank you. No. Okay. I think maybe it's different here than my computer. Yeah. And let's see, where is it? Tamarbuta. And it's just usually it's here. No, it's not here. Here. Well, okay. Then let's do Sharia. And the Tamarbuta. I need the Tamarbuta. Okay, thank you. Okay. Then you go to search. No results. How is?
Because you put only mufradat.
Okay. It was in lemata. It was in lemata exactly. And then now in mufradat. Yeah. So you have 8 documents, and this is because we are going to talk about this. You see that the word start in the 12th century in marriage contracts, and later in in contract of sales after the 14th century, 13th century. So this is why I wanted to show this word.
Can you see also the image of the papyrus itself? Or is it just the content?
We can, I'm here when I just have this. Some of them have the images, yeah, but not all of them.
Some of the students have never seen a papyrus.
A papyrus.
I'd like to show them what these documents are.
Yeah. Let's see. This is Egypt, Fayoum, we said, and then Serge, and I there you have here an image. Let's see.
And some of these are from the 1st century of Islam.
Yeah.
Which is
So, yeah. I have some in my presentation, some pictures also, but yeah. Yeah. Yeah.
people still say that, we don't have documents from the 1st century, but we have all these.
Yeah. We have, yeah.
From the time of Omar, we have papyrology.
Yeah. Okay. So, and then I will just show the paleography, which is also very interesting. This work is all still going on, and then you can see line orientation. Then you have here, let's see, which line orientation. There has been different horizontal, or you have rising. So you just choose one, and let's say just descending, and then you choose maybe the slant is how the aleph is working to the left, to the upright, let's say also to the left, and choose value of if the letters, how are the letters, let's say just intermediate, and then choose value also, well, let's leave this, and then let's say slant 100, and then you look, zero result, okay. And this is also the frustrating part. You don't find always whatever you're looking for, but I think this may be this one, and then yeah, maybe without slant. I just or to the left. Let's see if I have. We are more lucky now. Oh no, I found before I was using it and I had some examples, and now, okay. But you usually if there are some examples, because this is a quite a new part, then you will find examples of this paleography type, so that you can. It helps you to understand your own document, because you can see how the Ein is going down, or let's see if I think descending, and yeah. Let's see if I just put 90 less, and that's kind of, well, I had to give up. I think depending on the combination, you just find things or not, and maybe the slant is something you don't need here to the left, or just straight maybe. And no, okay, then I just leave, but as I say, you find some examples, and this is just a work in process, so this is no, I should have, and so and then, yeah, you have here bibliography, you can give the author, and then you have the let's say, so that it's something you can play with, and of course ask us also certain questions to ask. Sometimes searching is not so easy, and we have web class, and in the web class, then we usually it's explained to the students who take part in the web class. But this is just something usually that Professor Kaplony does. This is the chairman of my department, and sometimes I'm also involved, but like this semester I was also teaching the web class. So now let's go to the typology, the research that I have been doing in this database. You have the earliest documents that you have is administrative documents and receipts. You have also official letters, protocols, receipts, ذكر الحق, and the contract of sales. You don't find them at the beginning, and this is I think it's a very normal thing. After a conquest, you don't need to buy anything, and later things are already legally established. And so this is something happening in Toledo after the Christian conquest. So then you have the first contract of sale in papyrus is from the 767, and they are animals. They are contract of sales of animals, and then the real estate. The first one is in the 9th century. So by the 9th century, we have a great number of contract of sales, and it is established. It reflects a process of incorporating daily life under the official Arabic administration and the establishment of a legal system. What's this here? No. We find also, regarding contract of sale, also a difference between mobile property and real estate property. So you have here an example of this mobile property, animals and slaves, and the difference between both documents have been going on until, they were different type of documents until the 13th century. And you have completely different formulas, and you don't have a law formula, and this is why I would like to try to speak about this law formula, especially because in this type of document, a guarantee from a person is the law formula. This is enough if one person is behind the transaction. And there is no witnesses, because usually they were oral witnesses. So, and this is one type, we just call it Hadama Ishtara, if you just go into the papyrology database. And okay. This is a real estate contract. This is already a very complex one, late one also. But this type of document is in the 10th century. They are already established with all the formulas, and the format is a quadrangle usually, and the law formula is always there, almost always. Some exceptions are also. And by the 10th century, both types, the mobile and the real estate, they just get one kind of standard contract with the typical formulas of a document. Yeah. So about the law formula, this is what was interesting for me to realize, is that until the 13th century, the law formula is not, it doesn't use the word Sharia at all. The law formula is Alabai Sunnat al-Muslimin or Alabai al-Islam. This is the most common one. And Ala Shart Ba'i al-Islam wa shurutihi. So this is until the 13th century, and you can check that in the APD. this is just one of these examples from Groman. It's edited in Groman, and you see here al-Ashard by al-Islam. So I have different. I mean, I have already all kind of examples that you find and you could find in the APD, and you notice that that I mean it's something that so hada bima tabaya alayhi. So it's something like there is a custom there. There is a way of doing things there. By the 13th, 14th century, this change. You have another type of document, ishtara, but sometimes you find also with hadama ishtara. This is the original contract of sale until the 13th, 14th century. And the formula here is or start to be the Sharia formula. Sometimes ala mawjib Sharia or just small formulas. This is something legal, like bara'atan, sahihatan, shari'iyatan, and or bi'a sahihan, shari'am. This is a typical contract in Al-Andalus and in Christian Spain, because Christians use these documents until the 14th century. The Christians conquest Toledo in the 11th century, and they were 250 years writing Islamic documents. and this is the typical. That's why I had to talk about Al-Andalus and Christian Spain, because both of them were using the same kind of documents. Even if the Christians introduced Visigothic law in some of these, but they were Islamic documents, and they just in Spain. I mean, Spain and Andalus and Christian Spain, the word Sharia does not appear. There is few documents at the end in Granada in the 15th century that use the word Sharia. But the word is Sunnah, ala Sunnat al-Muslimin, ala Sunnat al-Nasara, and this is so. This is the type of ishtara that is the common type in Al-Andalus and in the West, in the East, after the 13th, 14th century, you find also this type, and with the Sharia formula. Another feature also that it's interesting, that I also realized when I was doing the typology, is the use of tasliya. Tasliya is the formula, just then it was not used until in the contract until the 13th century. As a standard formula. So at the beginning we have the earlier documents that use only Basmala. Then from the 11th to 13th century they use Basmala Hamdala, and with them in the 13th century, and I always say Mamelukes just make the shift of the legal system, and then they use Tasliya. The Tasliya became just the standard. And Tasliya, you find from the beginning, from the 11th century, some examples, but as a standard, only 13th century. And in Granada, you find it also, Granada also in late documents, 13th century, 14th, 15th century. And the first contract of sale with Tasliya in the APD is from the middle of the 11th century. So, however, you find Tasliya in protocols and in private letters, but I refer now regarding what is just a legal system and contract of sales. So my theory is that Sharia had at the beginning a religious meaning, and that's why it appears first in contract of marriage, which has much more religious formulas, and even if in fiqh is part of mu'amalat, but it's an area that in between both ibadat and mu'amalat. And the first documents anyway are certificates of Umrah from Damascus. And then we find also documents referring to the Sharia al-Ruhban, the law of the other religious community. And as we have said, in Mu'amalat and contract of sales until the 13th century, there was no word of Sharia. In Al-Andalus, we have only Al-Sunnat al-Nasara, Al-Sunnat al-Muslimin, and we have also many different way of addressing a law. So we have fueros. Fueros is a Spanish word, and it means just privileges or just specific laws from a community. And then we have also the legal custom of the town. Ada, Sira. So you see the concept of law is not so, it's not the same that we could say today. This is one of the documents from Toledo with, this is Ala Sunnat al-Nasara, fi buyuihim wa ashriyatihim. And these are also the examples of the formulas that we find. And you see always Ala Sunnat al-Muslimin fi tayyibi buyuihim, and baina ahlihi, and so on. So this is just a screenshot because I wasn't sure if I could show you live. So these are the documents where Sharia start to be quoted in the documents, and this is 12th century marriage contract, and then 14th century and 13. And the word also shar'an is also the same, 13th century, and so on. We have these examples of Damascus, Shira'an Sahihan Shari'iyan, and Ala Mawjib al-Shara. This is what I have already mentioned. This is a document from Catherine Closter. It's my own picture. And you see here also Bara'atan Sahihatan Shari'iyan. So, and this is from the 13th century. And so the Haram, the documents from Haram, from the Christian Müller have been editing also, and have the same formula, Bi'r Sahihan Shari'iyan. So sometimes we find ala mujib al-sunnah or ala hukm al-shar'a, but later disappear this sentence, and just we have small sentences with the adjective shari. And so what I come to is that just to put into attention of the orality of the legal system versus the written culture that starts especially with the Mamelukes. In my way of reading the documents, we have also many performative formulas, which also tells about this orality, like shaking hands, safkan wahidan, and or iftaraqa bi abdanihima. This is just a way to say, okay, the contract is finished. And then these formulas we don't find, for instance, in Toledo documents, which are much more belonging to a written culture. Because of the situation in Toledo, the cathedral was the archives and the notary, and they were already writing everything, so they didn't have this experience of orality that we find in the East. And so we have here a document which is from Toledo also, that is a kind of register of property already in the 13th century. And then we have the Mamelukes. And the Mamelukes I will bring already into the conclusions or just thoughts about about this of this research. The documents show a development of the legal system expressed in the type of documents and their formulas, and this is very clear. I mean, I couldn't show every details because it's, you had to see the details really, but you see how the documents change and formulas until certain period, and then after that, standard. And by the 13th century, contracts of animals and real estates were considered of equal importance, and before it was not, and that's why at some point they became just the same standard contract. By the 13th century, the law formula used the form Sharia instead of Al-Abay al-Islam. The law formula Al-Abay al-Islam and Al-Sulat al-Muslimin and the other formulas, Afghan Wahidan, reflect the orality of the legal system as its origin, and the Sunnah, the word Sunnah, this is different from Sunnah Muhammad and so on. This word Sunnah is the practice of the community, the legal custom, and it's the framework of the legal. So the law was a kind of consensus in the community, is that it was what it was known to them from the previous generation. Besides that, of course, there was the work of the legal opinion of jurists and ruler, but it was something that it was more anchored in custom, in legal custom. And the use of Sharia for muamalat, for contract of sale, in my opinion, it shows a more complex legal system and a period when written culture was taking foot. So that with this written culture and this more complex legal system, we have also a more just a meaning of a law of a state. It's not, we cannot speak of state like today, but like an administration and under the Mamelukes. And this Sharia with meaning of revelation and it's belongs to another period before, and then it's the development of this written culture and also of this more complex legal system starts with the madrasas of the 11th century by Nizam al-Mulk, and they just became, I mean, law acquired just a more professional institutional quality, and this is all mirrored also in the formulas. And then 13th century, the Mamelukes upgraded the system of law and its institutions, helped by extensive use of paper, because even if the paper was used before, but we know now that it's in the 11th century when it started to be more available, and at this time it was already completely available. And of course we have also rivalry, I mean the organization in four schools of law working at the same time, and the Mameluk had to face the threat of the Mongols that ended up by submitting themselves to the Sharia, and the Sharia in that sense was a kind of legitimizing word for the Mamelukes, religious legitimizing word. So by the 14th century, well, we have said that already. Then we have the we have this this formula of Sharia, and I would say more of an idea of law that belongs to the administration of the state. And we have to take in account the Semitic of religious formulas, because sometimes we think this is just a religious formula, but maybe they're indicating much more than just to indicate a religious content. And this is this is very clear by the use of tasliya, which just emphasized the religious identity. And that was necessary in Granada, because they were just challenged by the Christian power. And it was necessary during the Mamluk time, because they had to legitimize a power that they couldn't just not by inheritance and not by belonging to the house of Quraysh, belonging to Quraysh. So, and the Sharia. So that's why we find, in my opinion, this tasliya and Sharia in these types of documents, and just to end up with our talk, I would say the documents speak from themselves, by themselves. So we have just to read them carefully. Thank you very much.
I'm glad to ask a question. When you were relating the legal documents in the Andalus compared to the legal documents in the East, where the Mamluks were developing the system, so why are we relating like two geographically abroad countries?
Yeah.
Couldn't we see some relation in the development of the legal documents in the East, in a way that the Mamluks were developed some sort of system that was already in the East and developed it, and not like...
Yeah, thank you. It's a very good question. I'm relating both because, well, first of all, because most of the documents we have are in Spain. There is a big number of documents that have been kept. So we have them in the APD, and in Egypt also. So mostly when I speak about this research, and as I say, it's a research process, these things can change. But at the moment, this is the results. And Al-Andalus took the documents from the East. It's just that they took it and they, I think, Al-Andalus specifically because of the Maliki school of law that is more attached to custom, that give more place to custom, they just use Sunnah. And then in the West, there was another. Of course, there are different developments, but the standard contract of sale is almost the same in both. And the origin of the Al-Andalus, or I cannot see it because we have not so earlier documents in Al-Andalus. We have documents from the 11th century. So, yeah.
Any more questions? Dr. Hanafi?
Yeah, thank you so much for really, this is surprising for me to see a counter argument of the orality of the Arab tradition. So you see, you see a very rich written document. So for me, as I'm sociologist, I'm not a historian, but this is really very surprising. Specifically, I was reading that the whole journal of Al-Adliya in the Ottoman time was created it's created because the Ottoman Empire lost land in what now is part of Russia and the below Islamic Republic, etc., that the Orthodox Church asked the High Port in Istanbul to produce a written rules. So this is why we have written rules in the Ottoman time. So of course you are talking before, but just I wanted to comment in how much we have oral culture versus written culture, and especially in legal documents. And I do remember when I attended the seminar of Muhammad Arkoun in Paris, that he was always making a big statement about the oral culture and how we that all our argument didn't take it into account. So for him, the most important in the history is the oral and not the written. So so this is my question.
Yeah, thank you very much, because I think this is the origin also of my research, because myself I went to Cairo to do research on fiqh, and when I was reading the fiqh book and I was comparing with the society I was meeting, the people I met around me, I thought, this is a huge discrepancy. How can be? You have this I mean, not nice text about fiqh and punishment and so, and then you have a society that is completely a good society with many values, and so I started thinking I had to do something against this, and that's why every time when I try to find, if I find some, because then I realize, okay, it is because in this culture you have the way the oral culture has so much weight than the written one, or even much more weight, and in the past even more. We are a written culture nowadays because of the West. Since the Reformation in Europe, the people had to learn to write and read, and before, the religion, it was a tradition. It was given in the families. You didn't go to a book and look for the book. I mean, of course, the Quran or the Bible, they were read and you hear and they were explained, but you have a life. And the modern culture, Western culture is putting an end to this. And that's why also there are many problems in the Arab world, because people just try to identify with text, because the society is more individualistic, and then we have just books in front of us. I mean, the hadith, you couldn't learn hadith until the 14th century if it was not with a teacher. You couldn't read the hadith by yourself. There was no way. So you had to have a personal relationship with people and really understand what was written there. So these things, it's just a very personal thing for me, because I confronted that, really, the dilemma of the written culture. The Arab culture in the Middle Ages was a very high culture, and they started to, I mean, it was the time also to develop the law that was not developed in other places, not in Europe. So there was a contribution regarding the law and the written documents and written culture, but the oral one, I think, it was much more important. And just a little anecdote, I have been traveling in Uzbekistan, and then I see in front of the house people just talking together. I ask, well, what is the? Oh, they are selling the house. So they weren't doing the contract there in front of the house. So for me, it's very clear, but it's very difficult to prove this orality, and that's why we had to find all ways. Okay.
Any more questions? Okay, with this personal note, thank you so much.
Thank you to you.
Join me in thanking Dr. Paterno.
Thank you. Thank you. Thank you to you.